everybody. And so we're going to look first here at this antitrust deregulation that'll set us up from the governmental regulatory standpoint to go into our securities discussion later on. And so the purpose of these laws is to discourage anti-competitive practices and the creation of monopolies. Okay, so, and the reason that the government feels that it has to be in the business of regulating that is because, as you can see, sometimes a business itself is not going to have the interest of consumers in mind. And so the idea that there is more competition in the marketplace means there will be lower prices and more leverage for consumers. And so obviously the government may need to get involved in that aspect of regulating business practices so that they do not urge closer and closer to creating a monopoly. See, Facebook, you know, it's not just enough to have Facebook, and now they buy Instagram and, you know, Twitter and Google and whoever. Once you look around, they will have the entire marketplace monopolized in that particular area. And so you want to pull back on that as much as possible. And so as you can see, they're talking about the beginning of this antitrust regulatory law scheme. And they start to talk about the Sherman Act, which is covered in our text. But in actuality, antitrust law is made up, as time has gone on, of 5 different laws to pick up places where one law did not, where it is found that one law did or did not cover the types of activities that businesses started to engage in. And that is what will happen with the law. You'll have a law, then somebody will figure out a way to wiggle around that, and then that causes the enactment of another law to fill that void. And so that is why we have these 5 laws here, the Sherman Act, which we talked about there in the history. And then as time came on, we needed to add the Clayton Act. And then we have the Robinson-Patman Act, which is a 1936 amendment of the Clayton Act, and the Seller-Kefauver Anti-Merger Act of 1950, which is also an amendment of the Clayton Act. This is that whole thing that I have been talking to you about all along the way here about how common law evolves.
Conspiracy to put the USFL out of business. Secondly, unfair monopoly of network television. Stadia to play the games in, player contracts, even media relations. USFL attorney Roy Cohn said Thursday the NFL has violated antitrust law by monopolizing every vital aspect of the game.
Tie up 3 networks when they dictate to you you can't play football when the fans want you to play football, when they tie up stadiums with leases so you have no place to play.
The NFL owners each made $14 million from television revenue last year. The USFL less than $2 million. NFL teams average almost $1 million in profit. USFL teams lose $3.5 million apiece. So is this action akin to a drowning man grabbing at razor-sharp knives to stay afloat? Donald Trump, who owns the New Jersey Generals of the USFL and represented the owners, answered this way.
I think we have an excellent lawsuit. We have a case of a total monopoly by the NFL, and we expect to be successful in court. We're not doing this for any other reason.
The NFL has reserved comment on the issues, but Commissioner Pete Rozelle did say Thursday, quote, "This suit is a transparent effort to interfere with our season and to lay the blame for the USFL's well-known problems and failures at someone else's doorstep," end quote. But the USFL says the NFL has been busy with a conspiracy committee whose only aim was to bury the new league.
They just put every roadblock in your way, which they can do by virtue of their economic muscle. And that is exactly what the Sherman and Clayton Antitrust Act say. If you do it, you pay treble damages to the people who suffer as a result of your doing it.
So the USFL will play this spring, but they voted to move to the fall in 1986, competing directly with the NFL. But Cohn argues the league is committed to the football. The networks are committed to the NFL at the exclusion of his client. Finally, the cast of characters is appealing as well. The mighty Pete Rozelle on one side, USFL Commissioner Chet Simmons, a former network sports executive, Roy Cohn, chief counsel for the late Senator Joseph McCarthy Senate panel, and there's even father against son. Edward DeBartolo Sr. of the USFL Pittsburgh franchise is in effect suing son Edward, who is the president and owner of the NFL 49ers. So the plot is already thick, and they haven't even gone to court yet.
We're wearing pads in court.
That's exactly right.
So we're going to look at this case a little bit here so that we can look a little bit more at how these horizontal relationships work. But first we're going to look a little bit at the Sherman Antitrust Act, just so we can get a better understanding of how it kind of works, and you'll see the mechanics of it when we look at our particular case. But it prohibits, in the first instance, actions or conspiracies that will restrain trade. And then the second part of Article 2 of the Act covers the actual monopolization, and then it also covers activities that are like attempted monopolization. And so we're going to see how this works in the case that we're going to look at, because it's going to go through these elements. And these are the elements that you must have in order for there to be an attempted monopoly. And so it is a three-part test. And so you have to establish that the entity must have a demonstrable and specific intent to achieve a monopoly. And then the entity must have acted in an anti-competitive manner. And then there must exist a dangerous probability that the monopoly can, in fact, be achieved. And so these three elements would have to be established to create an action on that second part of Article 2 part of the Anti-Sherman Act, what I call Subpart B, which is the attempted monopolization. You have your actual, and then you have your attempted. And then our book talks to us about the Clayton Act. And the Clayton Act, which we will see, you heard the attorney in that particular clip talking about treble damages. So after time went on, the Clayton Act was brought along to treble, what we call treble, or 3 times the damages that are asserted. So whatever the jury awards, then that award, a damages amount, will be triple the amount. This is to definitely put a curb or to discourage anti-competitive activities. And so if you have a situation where you're sued and it's $1 million in damages, and then that is tripled, that would be $3 million, that's going to be a message to the entire marketplace that will curb these type of activities. And so this is one of the features of the Clayton Act that came about that you will also see being used. And so we're going to look at this case a little bit, just some of the key portions of it. But here is our United States Football League versus the NFL. And so here are the facts of the case, but the actual facts were laid out pretty close to what we need for this particular discussion. But you'll see here, this is what the case is brought for. This is that thing I was telling you about earlier, where we were talking about how the Department of Justice or the Federal Trade Commission can enforce this. But these can also be enforced by private individuals like you and me, or any business that believes that it has suffered some type of injury based on some type of anti-competitive activities that are going on in the marketplace. And so here the United States Football League is bringing this case based on violations of what we talked about just a few minutes ago, Section 1 and Section 2 of the Sherman Antitrust Act. And so I highlighted this because after the trial, the jury did find that the United States Football League's first claim of actual monopolization, concluding that the NFL had willfully acquired or maintained monopoly power in the relevant markets. And then this is going to be a very important word here, because the jury also found that this unlawful monopolization of that relevant market caused an injury. And so then the facts also tell us that the NFL found that the jury found that the NFL had not violated Section 2. To me, once you find that there is actual monopolization, to me there is not even a need to go into whether there is attempted, but then they found that they had not violated Section 2 by attempting to, or conspiring, which is kind of like, it's a different type of a thing. It's like people doing something, a conspiracy, getting together in a, intentional way to do something. In this particular case, it was just actual. It wasn't like, some type of a concerted effort with a co-conspirator to actually just go in and attempt to monopolize the industry. It was just by way of how the business model is set up. And so this is going to be more of the interesting feature, however, is that even though the jury found that there was an injury, they only awarded $1 in damages. And so, thank you very much. Thank you. Okay, but the story, it's not a sad story. Because, and see, this is what the NFL was banking on. They were banking on the fact that, to me, when I look at this case, I can see there was some gray area in the legal analysis portion of it, because it seemed to me that the NFL did not account for the fact that the Clayton Act could come in and save the day, and that is what happened here. So because of the Clayton Act, if the Sherman Antitrust Act is violated because of the Clayton Act says that is an anti-competitive practice, and so then you must be awarded attorney's fees. And so in the end here, what ended up happening is that the court awarded the United States Football League over $5 million in attorney's fees. And so the NFL was completely, I feel when I read the case, they were completely just oblivious to that being able to happen, because it didn't seem like they were ready. And so they came up with some arguments that are just kind of, off the wall. And when we have talked in the past about the cause of action of negligence, one of the elements is damages. The problem here is that the NFL that's why I say when I look at it, I can tell they were not ready for the argument. because they took injury to mean damages. In negligence, you have to be able to establish your damages, your monetary damages, okay? But because the jury came back and said it was only $1, they were like, okay, well, how can you have damages if you only had an injury that was $1, that was worth $1? And the court says, no, injury and damages are not the same thing. That because the jury found that there was actual monopolization, that all they need to do is establish that there is an injury, and then the Clayton Act says that you must, is not you may, or you can if you want to, you must be awarded, the injured party must be awarded their attorney's fees. And so that is how we can see how the Clayton Act comes in to fill some voids that were not contemplated in the Sherman Antitrust Act. And now because of the Clayton Act, businesses are going to think twice before they enter into anti-competitive practices. And so in the end, the district court, the trial court, went ahead and they allowed them to keep the $3, and then they awarded them their $5 million in their attorney's fees and an additional amount for court costs of $62,000. Now, I have another extra credit question for you. So, if the NFL decides that it wants to appeal this case, here's our question. Since this case is in the United States District Court in New York, if this case is appealed, which circuit court of appeals will have jurisdiction over the case? Which circuit court of appeals will have jurisdiction? Yes, sir.
I'll guess.
Okay.
Second.
You didn't guess, you saw it on my side. You good at that?
I guess.
That's very good, Mr. Shades. Yes, the Second Circuit Court of Appeals. That's pretty good. I don't see that as much. Okay, very good. Yes, the Second Circuit Court of Appeals. See, remember our map? And I saw some people, they were looking for that map. Yes, they were looking for that map. I heard you all looking for it. And so here we see that up here in New York, that's going to be our Second Circuit Court of Appeals. So if that case is appealed, then it's going to go to the Second Circuit Court of Appeals. Now, so do you think the NFL would appeal that case? You think the NFL would appeal that, the $5 million in damages in attorney's fees?
No.
I mean, they have the money. You don't think, you
No,
say
I
no?
I don't think they would appeal it.
Really?
Nothing else, the damages were $3, so.
No, but the NFL, because now they have to pay the $3 plus the $5 million in attorney's fees.
But they're not broken up or anything like that from the ruling, right? So.
No, you're right, they're not, but,
So I'm saying that they got, the next
that's
one
right.
could have been way
You would
worse.
think that, hey, just keep on going, pay the little $5 million. But guess what? They did appeal. Guess what? the case went all the way up to the Supreme Court. I previewed this slide too quickly. But NFL must pay. They went all the way up to the Supreme Court. They fought that. They went to the Second Circuit Court of Appeals. The Second Circuit Court of Appeals said, this is in order. I mean, once you have a statute that's written the way the Clayton Act is written, it doesn't say maybe. You can if you want to. The court has discretion. It says you must award the attorney's fees. And so they brought in their, they ran up their attorney's fees little thing from the computer. Times, I bet you it was like $2,000 an hour. I can't imagine how you get to $5 million, but they came in with $7 million, and the judge reduced it based on the evidence, and so then they appealed it to the Second Circuit Court of Appeals, and then after the Second Circuit Court of Appeals sustained the ruling of the district court, then they went up to the Supreme Court, and the Supreme Court just let that particular ruling stand. And so they ended up having to pay that. I mean, can you imagine the amount of attorney's fees? I mean, they had to pay additional, the NFL, to take that case all the way up to the Supreme Court. So you can see how serious they are about, pushing back on these particular types of regulatory laws in the anti-competitive scheme, because this is something that is very prominent in the NFL, and really most of the major league. I mean, because you don't, when you get ready to watch your basketball, you don't watch the NBA. You're not. And then when you get ready to watch hockey, you're going to watch the National Hockey League teams. I mean, they're kind of like self-made monopolies, and so they have to be, some of their practices have to be closely watched. And because we have the ability of the regulatory agencies, the Department of Justice, the Federal Trade Commission, and private citizens to act as watchdogs against these particular activities, then that's how we we fight back against the industry to keep things in check. And so this is like an example of your horizontal. You have businesses that are on the same level that are trying to compete with another business of the same like and scope.